The Supreme Court of Nigeria on Friday stopped the Central Bank of Nigeria and the Accountant General of the Federation from allocating funds to the River State government, until valid appropriation law is passed by the River State House of Assembly, is the rule. A 5-panel of the Apex Court ordered that Martins, Emoele, and 26 other members who were illegally excluded from functioning as members of the River State of Assembly to resume immediately. This decision follows the position of the court that the action of the River State Governor, Governor Fubara, throughout the political saga had been born out of fear of impeachment. He added that there is no justification to attack the legislator or act in the breach of the rule of law, and clearly faulted the action of the state governor, which includes the demolition of the House of Assembly. In a related development, Nigeria's Apex Court also on the same day issued an order to nullify the recent local government elections, which saw the People's Democratic Party making a clean sweep of the 32 local government areas of River State. The Court of Appeal had set the ruling of the Federal High Court on the matter when it was approached by the River State government. After this latest development, both the People's Democratic Party, PDP, led by Governor Fubara, and the opposition of the All Progressive Congress, APC, which many say is curiously being led in proxy by the former governor and current federal and minister of the FCT, Nyesom Wike, who officially remains a card-carrying member of the PDP, are now left reassessing their positions. To make sense of it all, I am now joined by Jiti Ogunye, a public interest lawyer and principal counsel at Jiti Ogunye Chambers. Many thanks for joining us, Jiti. How are you today?
Thank you, Professor Killer, for inviting me. I'm fine.
Good to have you. The situation in River State is so convoluted that I even struggle to express the introduction. Help us make sense of it, legally and politically, just to break it down for simple, God-fearing citizens of Nigeria.
Now, thank you. You're correct to assess the River State political situation or crisis as convoluted. But let me declare here that, but for vested interests and the antics of political actors, the matters are not that convoluted, at least from the judiciary angle. Generally, and this is my general broad statement, political matters that ought to be resolved within political parties or amongst politicians, too often these days are taken to the courts for litigation and adjudication. And unwittingly, therefore, the courts, in most cases, then get caught in the crisis by the plenitude of decisions that are rendered by the courts, bearing in mind that the appellate process is there. So, High Court, the Court of First Instance, Court of Appeal, and the Supreme Court as the Apex Court. And in many instances, their decisions are usually not concurrent, as we'll later understand in this case. One of the cases that have been decided by the Supreme Court. The High Court decided the matter one way, the Court of Appeal decided the other way, and the Supreme Court decided the way the High Court decided it. So what we've had over time, therefore, is that politicians are insistently using the judicial turf as an extension of their political turf for jostling for control, for superiority, and for advantages. And this need not to be so, because our judiciary is inundated with political cases. The dockets of our courts are full, and the more political cases that are taken to our court, the more likely it is that some of the judges determine these cases become so exposed to politicians and what the politicians use to corrupt institutions. So I think that it is necessary, moving forward, for the judiciary to develop a rule of law, flowing from all this case law, or for outright legislation to further streamline instances in which politicians will go to court. Now, in all the political cases that have been decided in this climate and elsewhere, political cases are usually not very suitable for the resolution of all political disputes. Not in the case of Awolowo and Shagari, not in the case of Gore and Bush, even in the United States, because people will still say, okay, we respect the court, but you see, the matter ought not to have been decided this way. Not in the case of Buhari and Obasanjo, Buhari and Yar'Adua, and in all the other cases, including the recent one. So the more politicians learn how to leave the court alone, and the more the courts, try to, regulate and streamline the cases that come to them, the better. Now, in Rivers State, it's no longer news that Governor Sim Fubara and his political father, or godfather, Nyesom Wike, had a crisis very early into the tenure of the governor. And the crisis blew over.
If father at all is going to be former father now, if it's probably ex-father. But go ahead.
As godfather, okay, for the purpose of yes. And so soon the crisis blew over, and the crisis then manifested in the House of Assembly and in the executive branch of government. Mind you, the way the executive was constituted, including the emergence of the governor as a governor, was not without the knowledge and say-so of that godfather. So the executive was divided between Wike's loyalists and the governor's loyalists. So was the House of Assembly. Now, at a particular point in time, the Speaker of the House of Assembly, leading 26 other members of the House, loyal to the ex-godfather, as you've corrected me, declared, openly that they were defecting, and they hoisted the flags of the party to which they claimed they were defecting to, and all that. But as it later turned out, and I'm summarizing it now, what they did appeared to be sheer political grandstanding or posturing. Using political language, freely, just to taunt the governor and all that. Or perhaps they meant it, but eventually they felt that they should backtrack. Mind you, George Orwell has said that political language as a camouflage is designed to make lies sound truthful and modern respectable. Yeah. So politicians can say whatever they like. But what was important was that the procedure for defecting, for moving from one party to the other, writing to the local branches of their political party, submitting their letter of resignation, writing to the other political party, accepting their membership form, abandoning the membership form or the other, all these procedures appear not to have been consummated, perhaps because they were playing politics. But the governor, who was, struggling to assert himself, seized on that and said that the seats of the members of the House have been declared vacant. And a lot of people have spoken about this. And that's why I said that the matter ought not to be disconvoluted. When a crisis occurs in a political environment, particularly in Rivers State, that is, relatively to, or in comparison to some other states, is awash with political money to be spent. Lawyers like me, including senior ones, pundits who are willing to go to television houses and elsewhere to just one party or the other, analysts, other politicians who are opportunists, all of them will converge and start saying, oh, these are the issues, it's the breach of the Constitution, and so on and so forth. But what was clear was that when that issue of defection was being said, you should care. If anybody had cared to look at the provision of the Constitution, it will be clear what could have been done in the circumstances. And that's the explanation. Section 109, paragraph 1 or subsection 1, paragraph G, governs defection. And that provision says that the seat of a member of the House of Assembly sponsored by one political party will be declared vacant, or a member shall vacate his seat if he, having been sponsored by one political party, then defects to another political party, provided that that defection or is becoming a member of the latter party is not as a result of merger of his erstwhile party and a new one, thereby adopting a new name, or is not as a result of the division of his political party, right down the middle, from top to bottom. Now, that provision and the proviso have been, interpreted by the Supreme Court in the case of Abegunde and Ondo State House of Assembly, decided in April 2015. And the Supreme Court said that the kind of division within a party that will be recognized as a basis for any member of the party to defect to another party will be a wholesome division, a division from the apex structure of the organization to the lowest one, in two parts. That's the kind of division that will be recognized. Now, and this is the key, subsection 2 of section 109 says that the Speaker of the House shall give effect to the provision. What then happens when the Speaker himself, as in this case, was said to have defected? What will happen? Anybody that believes that he has interest, be he a member of the House or the Governor or the Attorney General, should from that point have approached the court to seek for an order of mandamus, or by originating summons or originating motion, judicial review, to say, look, compel the Speaker to give effect to the defection of not only the Speaker, but the other members. That is part of the rule of law. But in this case, that was not done. Rather than doing that, the governor, perhaps desperate to protect himself, went ahead and constituted his own 4-member house, which is bizarre, and then went ahead in the name of construction or renovation to move on the House of Assembly and demolish it. That's anarchy. And you recall that had occurred earlier in Edo State under Obaseki, who is no longer in the country now, when in proclaiming a house in Osadebe House, the seat of the government, he proclaimed the house with some members being present, and he said that they were the only legislator that would be recognized. About 14 odd members were not recognized for an entire legislative term. And throughout that period, he also moved on the house, dropping gravels, removing roofs, and so on and so forth. So if a governor that is elected under the rule of law and the Constitution will not allow the first arm of government in a representative government, because democracy is a representative government, to sit, what then do we have? We have totalitarianism. We have dictatorship. Yes. And so the matter then went to court. The matter was litigated. Omotosho G, of the Federal High Court, James Omotosho, Justice Honorable Justice James Omotosho, sat on the matter and said, look, you cannot claim to have had your own house until perhaps you go to court to have this seat declared vacant and to get rid of the members, the 27 and the majority. They remain the house. So present your budget before them. And the matter then went through to the Court of Appeal. Before it got to the Court of Appeal, when the governor would not comply, the 27 legislators then went to Abuja. Federal High Court also, Honorable Justice Joyce Abdul Malik also sought to enforce the earlier order of Omotosho J. And the matter went through the Court of Appeal and finally to the Supreme Court. And it was good that in the decision of the Supreme Court, And I will salute their judges for, covering all the issues, including the resort to self-help and demolition of the house. That's executive recklessness and lawlessness. And they cover all
and that is a very...
And for me, that was a very good judgment.
A very good element. So there are two things here.
So that's the issue. The other issue is the local government issue.
Yes.
But that was the basic issue that lingered up to now. The whether the 27 members are defected and who can enforce that defection if they will not relinquish their seats having defected. The idea that many that I regard as confusing the issues have, impudently argued, that 3 members or 4 members of the House could constitute a legislature. Is so strange to me. And these courts across the board, including lawyers, who are saying that those people are defected, so their seats are vacant, that's the end of the matter. That cannot be the end of the matter, as we now realize, because the Supreme Court has said that,
the Supreme Court has now...
How can you so insist?
The Supreme Court has now showed us that that is not the end of the matter. 2 things here, though. Let's look at something of substance and something of institution vis-a-vis the rule of law and separation of power. There is an implicit fear, which some of us share, of catitocracy, this rulership of judges, rulership of court, because politicians, as you alluded to, keep running to the court, be it for the internal party affairs, be it for after they've been elected, which shows some kind of weakness or mischief on part of politicians to run to the court. But here's the thing, though. We have a catch-22 situation on 2 levels. Level 1, if they run to court, we accuse them of running to court. If they don't run to court, we accuse them of anarchy. What should they be doing there? The other issue here, still on our catch-22, is that this Governor Fubara, rightly or wrongly, legally or not, there was a main concern that these people are going to impeach him. So what, moving forward, what are the lessons to be learned here? I say lessons because in reality, the lessons of the past was in Edo State, where there was no consequence. Here we're seeing consequence. So I think people need to choose their lessons very well. What is your advice for the governors of the future, or the ones of the present that the same thing might happen too soon if they're not careful?
Thank you. 2 important questions. The first has to do with what we do, the catch-22 situation. I think that what needs to be done is for our institution to maintain a critical balance. Access to court, access to justice is guaranteed by our Constitution. Section 6 of the Constitution is there, Section 6(b) is there. In a democracy, if there is a civil dispute, the judiciary is the arbiter, and so the matter is expected to be taken to the court. More so if the dispute has the semblance of a clash of power between the executive branch of government and the legislative branch of government. So it is the judiciary that should handle such a dispute. So that provision in the Constitution must be preserved in order not to have a reign of anarchy, in order to curb the penchant to have recourse to self-help. However, and that's why I'm saying that we need, moving forward, to maintain a critical balance. There's been increasing concern about the litigious disposition of politicians, who in some cases, even when no cause of action really has emerged, they fabricate one in order to take advantage of their opponent. Whether it's about seizing control of political party, we saw this happen a lot, during the Buhari presidency, when the APC was in semi-crisis or was in actual crisis, and they were trying to take away their chairman and all that. So they were going to court to obtain orders of injunction, orders, even when there was no apparent crisis. So they do this a lot. So what our institution needs to do, and I'm talking about the judiciary, and that's why I said that by their interpretation of the law, they become more strict, in saying, yes, the jurisdiction is there, the access to our courts is there, but you just can't be coming to court every time and then be bringing frivolous. So it is not just by way of language. When the court says this is an abuse of court process, this suit is vexatious and frivolous, they should be looking critically at those suits to see whether those suits will be non-suited or struck out or dismissed. And I've reflected on this a lot.
I can
it's not
see
just
that.
On top of my head.
Yes, I can see that. Yes.
In our jurisdiction, in our jurisdiction here, there is a rule with the running of a trade union. If you have a trade union, and a trade union, there's a crisis in that trade union, and a member of the trade union wants to just dash to court to say he wants to bring a suit, the question the court will pose is that, have you exhausted the internal remedies? Is your suit ripe for litigation? And then they use that to keep at bay people who may have penchant for just coming to court on the drop of a hat to inundate the court with frivolous applications and all that. But now, on the second issue, so I recommend that court will have to look at this. The second one is the advice to Governor Fubara going forward.
Yes.
Quite frankly,
and governors like
with what I've advocated here this evening and elsewhere about the need to find political solutions. The presidential intervention by the president that the parties recoil away from and they refuse to embrace was a good resolution platform. Quite frankly, because that resolution had an assurance or guarantee of non-impeachment.
Yes.
It was there. And so why the governor reside from that, and rather listen to some people in Rivers State and elsewhere who are urging him on, go forward. I don't know.
Well,
so
it was argued
that
then,
part
Jiti,
is still
it was
open.
argued then.
My recommendation.
Yes, is still political. It was argued then that part of the conditions were too stringent and not edifying for him, that he had too much to lose. Just for our viewers to put into context.
Okay. My response or short riposte to that is that politicians should stop grandstanding. How did the governor himself emerge?
Yeah.
Have you forgotten that the governor was the accountant general in that state, and for 2 years was declared wanted by the FCC? And this Nyesom Wike used his political will to prevent the FCC from moving on him. So they were coming from the same place.
They're coming from
so
the
why
same
couldn't they
place.
resolve their crisis and allow governance, real governance, to take place there?
Which is what the
I don't like grandstanding.
Which is what the people really care about. Just one last thing before you go, because we need to wrap up now. From what you're saying, it appears that you and many others like you have interest in protecting the judiciary, especially the bench, from undue exposure. And that is why you give the example of the trade union. That is why you think institutions need to be stricter and more rigorous before admitting pleas of different way. But let me play the devil's advocate, but not too much, because I actually believe this. What if the judiciary enjoys this attention? What do we as a people do? Whilst we're trying to save them, what we call undue attention, what if they enjoy being the king makers, either individually or as a collective? What option is left with us?
Now, society will not be reformed if society has to eternally and perpetually wait on the whims and caprices or disposition of actors whose actions are inimical to progress in society.
In
The way society get reform is to pull back and look at that society.
And say,
and then, think through what needs to be done. Look, this has been a concern before now. 1979 Constitution, 1989, even under the 1999 Constitution, resolution of election petition was a two-tier thing. Tribunal and then Court of Appeal for gubernatorial cases. For presidential petition, Court of Appeal acting as a tribunal, and then the Supreme Court. Then what happened? By some strange, development, the Constitution was amended. And so, gubernatorial cases, governorship petition now becomes a three-tier determination. And so our court perpetually are inundated with political cases, some of them that are timed and are given preference and priority to the detriment of ordinary civil and criminal appeals. This is not good for society, apart from, further and further exposing our judiciary to the possibility of corruption and compromise. And so I think that even if there are some judges that we to be having these cases coming to court, society must step in and say, this is not good, this is not healthy. Recourse to adjudication in political cases and election matters should be an exception, not the general rule. In this jurisdiction now, you see some of our lawyers saying that, yes, they are election petition experts. Because they expect that every round election, there must be crisis. That is not correct. It's an exception. How many cases of Bush and God you have in the United States and elsewhere? Why must we perpetually be waiting? If indeed now there are judges who lobbied, and I say this with all respect, to be put on tribunals.
Thank you for
the last time I learned that some judges of National Industrial Court are on election petition tribunal, I said, National Industrial Court.
What are they doing there? You said
so
to yourself.
So why should they go there? So I think that we must save our institution. We must insulate it. And this is a call. I'm making this call using your esteemed platform, for reform in this regard. The politicians will be labored in the Nigerian judiciary and weaken it by all these cases. All the people talking about testing the law, growing the law, going there every day. That is not. It's not the correct way to go. I think that while we need to preserve access to court is something that bothers me greatly. That I think that the judiciary, the legislature, and everybody in the legal community in Nigeria must have a serious thought about.
And the last beautiful word, and the society. So thank you very much, Jiti Ogunye, who has shown himself not just to be a lawyer, a friend of institution, a scholar, a student of the history of law and history and philosophy of law. Students of philosophy of law will know what you refer to when you talk about the society taking charge in cases where organs of the law or the society tends to deviate, where exceptions become the norm. Thank you very much, Jiti.